Okay, the person signing in on the Motorola device, can you tell me your name, please?
Kara Fable.
Stable, okay. Might be 1 second, and then we're going to call your case, okay?
Okay.
Thank you. Hi, on the Motorola device, can you tell me your name, please?
Michael Fable.
Mr. Fable, okay. 1 second. I'm just gonna put you on hold for 1 minute, and then we'll call your case.
Okay.
Thank you. Okay, looks like we have all the parties connected on the Beeland file, so we'll go on the record in Beeland versus Beeland. This is file number 19895. If I could just have both counsel put your appearances on, please.
Sure. Good morning, Judge Elliott Blumberg, on behalf of the plaintiff, Chauncey Beeland, who's appearing via Zoom from my office.
May it please the court, Attorney Matthew Boucher appearing on behalf of Brittany Beeland, who is appearing via Zoom from her home, myself from my own office. Thank you.
All right, thank you. So we're on the record today for a status conference, and it looks like there was a order entered with regard to custody, parenting time and so forth back in the early part of April, but in terms of resolving things from the property standpoint, Mr. Blumberg, can you tell me where things are at?
Judge, I think, yes, I'm sorry. The parties, I think, have come to an agreement on all of the issues. However, earlier this morning, I was contacted by counsel. There's one marital obligation that is not yet resolved, but it shouldn't prevent us from taking the proofs today if the court would allow us and having a judgment prepared, which would ultimately resolve that one issue.
Okay, Mr. Boucher, is that how you want to proceed as well?
Yes, I agree with opposing counsel, Your Honor.
Okay. So you said, Mr. Blumberg, you have Mr. Beeland there at your office?
Yeah, I do. I'm sorry. I should bring them into the picture.
Good morning, Your Honor.
Good morning, Mr. Beeland. If you can raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you. You can lower your hand, and Mr. Blumberg, whenever you're ready, please proceed.
Okay, Chauncey, could you state your full name for the record?
Yes, it's Chauncey Shane Belland.
And you are the plaintiff in this divorce action, is that correct?
Yes,
Is it true that you had filed a complaint for divorce, and in it you had alleged that you had been a resident of the state of Michigan for at least 180 days immediately preceding your filing? Is that correct?
yes,
And you further alleged you'd been a resident of Otsego County for at least 10 days prior to the filing of your complaint. Is that also true?
yes,
You allege that you were married to Brittany Beeland on April 25th of 2015 in Otsego County, Michigan. Is that correct?
yes,
And that ceremony was performed by an individual who was authorized to perform marriages. Is that correct?
yes,
There were two minor children born in this marriage. Is that correct?
yes,
That would be Liam and Elena.
yes,
And both you and Miss Beeland have come to an agreement as to the issues of custody, parenting time, and support. Is that correct?
yes,
You understand that you both will share joint physical and joint legal custody of the two minor children,
yes,
and that you've come to a parenting time schedule that effectively allows the children to spend equal amounts of time between the two homes. Is that correct?
yes,
You alleged in your complaint that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Is that true at the time that you filed this action?
Yes,
And is that true today?
yes,
Now, there is a marital home that currently Ms. Beeland is living in that is going to be placed on the market and listed for sale. Is that your understanding?
yes,
And that upon the sale of that property, the proceeds will be divided equally between you and your wife. Is that correct?
yes,
Um, per the agreement, you understand that neither party will be seeking spousal support. And spousal support is not going to be awarded to both you or Ms. Phelan. You understand that?
yes,
And that neither one of you will be able to come back at a later date and ask the court to revisit that issue.
yes,
Okay. In terms of the personal property of this marriage, have you and she come to an agreement as to how that's to be divided?
yes,
In terms of the agreement as it relates to the children, do you believe that to be in their best interest?
yes,
And as to the division of both the debts and the assets of the marriage, you believe that to be both fair and equitable?
yes,
There is this one issue that we learned about this morning, and you have not at this point agreed to the resolution of that, but upon the documentation that would support such a claim, you'll come to an agreement. Is that correct?
yes.
Okay, thank you. Judge, I have no other questions.
Thank you. Mr. Butcher, do you have any questions for Mr. Beeland?
Just a couple, if I may.
Okay,
Mr. Beelan, as it relates to parenting time, is it your understanding parenting time will be on a week on, week off basis, beginning and ending on Fridays at 3 p.m. unless the parties agree otherwise?
Yes,
And as it relates to the other debt, is that related to a Navy Federal credit union debt, credit card debt that is in my client's name?
yes. As
Okay.
referring to the last issue you just brought up.
Yeah, okay. As it relates to personal property, you agree that all personal property has been divided?
Yes,
As it relates to vehicles, you have a vehicle that is in your name, titled in your name, and my client has a vehicle in her name that is titled in her name, and you guys are both going to keep those vehicles free and clear of each other. Is that correct?
yes, correct.
And it's your understanding that the home has been listed and that the proceeds will be split equitably outside of this other debt that's to be investigated or looked at between the parties. Is that fair?
Yes,
And if that debt is a marital debt, that will come off the top of the house proceeds, and the house proceeds will be split from there. Is that your understanding?
I don't think that is anybody's understanding at this point. That's the remaining issue that upon proper documentation, we will certainly resolve.
Okay, that's fine. I have no further questions. Thank you.
Judge,
All right,
can I ask one further question to my client, please?
yes,
To your knowledge, Mr. Beelan, is your wife currently pregnant?
no,
Thank you.
not to my knowledge.
all right. Mr. Butcher, did you want to take any testimony from your client?
Yes, just briefly, Your Honor.
Okay, Ms. Beeland, if you can raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you. Go ahead, counsel.
Ms. Beelan, do you have an opportunity to hear the proofs presented by your current husband, soon-to-be ex-husband?
I'm sorry.
Did you have an opportunity to hear the proofs that were just presented by your current husband?
Yes,
Do you believe that those proofs are accurate as far as custody is related?
yes,
And do you believe that they are accurate as it relates to property?
yes,
As it relates to custody, it's your understanding that custody will be a joint custodial arrangement, both physical and legal?
yes,
Parenting time being a week on, week off basis, beginning and ending on Fridays at 3 p.m. year round?
yes.
And are you currently pregnant?
No,
You had an opportunity to hear about spousal support, specifically that there is no spousal support being awarded. Is that accurate?
yes,
You're not expecting any spousal support,
no,
and you're not expecting to pay any spousal support.
no,
You understand that spousal support will forever be barred?
I understand.
As it relates to personal property, is it your understanding that all personal property has been divided?
Yes.
And is it your understanding that the vehicles that you have and Mr. Beelan has have been equitably divided?
Yes.
Do you believe that the custodial arrangement and the parenting time is in the best interest of the minor children?
Yes.
You understand that the home is listed for sale and the proceeds will be distributed equitably, essentially split 50-50.
Yes.
There is a concern about an outstanding debt with Navy Federal Credit Union, I believe totaling over 6,000. That is still at issue. That's your understanding?
Yes.
And you understand that that's going to be resolved, I suppose, here after the proofs?
Yes.
Okay. Is there any retirement accounts, 401ks, or any other type of investment accounts in your name?
No.
Is it your understanding that Mr. Beelan doesn't have any such accounts in his name?
What I know of, yes. He doesn't.
Do you believe that there's any other property that has not been discussed here today?
No.
You understand that you had a right to a trial on this matter?
I understand.
You understand that the judge could have ruled more favorably, less favorably, or substantially the same as this agreement here today?
I understand.
You're asking the judge to take these proofs from both you and Mr. Beeland and ultimately enter a judgment of divorce based on your agreement,
Yes.
and you believe it is equitable?
Yes.
Do you have any questions from me?
No.
Do you have any questions from the judge?
No.
No further questions, Your Honor. Thank you.
Thank you. Mr. Blumberg, did you have any questions for Ms. Beeland?
I do not, Judge.
Okay, thank you. The court has heard the testimony of both parties. The court finds that the statutory grounds for divorce have been met by that testimony. The court will grant the divorce. However, the divorce will not be final until the judgment is submitted to the court for signing, which, as indicated by counsel, the court expects will do in a timely manner. So I'll sign that as soon as it's been presented. Mr. Blumberg, anything else that we need to address for your side today?
I do not believe so.
Mr. Bocher?
No, Your Honor. Thank you.
Okay. All right. That concludes this hearing. Mr. Blumberg, I've got a couple cases that I need to address before your matter at 9:45, so I'm just going to put you on hold.
That's fine. Thank you, Judge.
Thank you.
Go.
Okay. Ms. Morrison, are you able to hear me okay?
I am, Your Honor. Are you able to hear me? My connection has been a little bit funky the past couple days.
Yes. And Mr. Morrison, are you able to hear me?
Can you?
Yes, sir.
Okay. All right. We're on the record in Morrison versus Morrison, file number 231963. This matter was set for a hearing today. Looking at the file, it looks like the parties have a contested hearing coming up on May 19th in front of the referee regarding a custody issue. We need to have that hearing first before we can move forward and or finalize anything in terms of the divorce. So it would be my intention to set this for a hearing following that May 19th date. Ms. Morrison, do you have any objection to that?
No, Your Honor.
Mr. Morrison, do you have any objection to that?
No, Your Honor.
So that's how we'll go forward. The court will send out a notice of the date and time for that hearing. And again, just make sure that you're both ready to go on May 19th before the referee. And you're both free to disconnect at this time. Thank you.
Thank you.
Thank you, Your Honor.
Okay. If I could have you both unmute, please. All right.
Good morning.
Good morning. We have both parties connected. This is the case of Hoggard versus Hoggard, case number 2419902. The record should reflect both parties are present today by Zoom video. I have this set as the date to enter a final judgment of divorce in this matter. Ms. Hoggard, is that how you wanted to proceed today?
Yes. Good morning.
Morning. And Mr. Hoggard, is that how you wanted to proceed as well?
Yes, sir.
Okay. So I'm going to have you both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
I do.
Okay, thank you. You can both lower your hands. I'm going to be asking you each a series of questions. The questions that I'm going to be asking you are the questions that I'm required to ask in order to establish the grounds for divorce under Michigan law. And so as the filing party, Ms. Hoggard, most of my questions are going to be for you. First of all, you did file a complaint for divorce in this matter and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there has been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, sir.
Does that remain true today?
Yes.
If the court were to refuse or decline to enter a judgment of divorce in this case, is there any chance that the marriage could be reconciled?
No.
There's one minor child born in the marriage, is that correct?
We have 2 children, but our daughter's 21 now.
Okay, one minor child then. Okay. And under the judgment of divorce, it provides that essentially you would share joint legal custody and have an equal number of overnights with the minor child that remains. Is that true?
That's right.
All right. And as the mother of your child, do you believe that that arrangement would be in your child's best interest?
I do.
Under the proposed judgment, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever, and that you would not be able to come back later and ask the court for that?
Yes, I do understand. Thank you.
And because you would be sharing an equal number of overnights of custody with the child, there would be no payment of child support. Do you understand that? In terms of the assets or debts of the marriage, have you divided all those up with Mr. Hoggard?
Yes, we are divided.
And do you own any real estate or real property together?
No.
Okay. Are there any issues regarding the division of any assets or debts that remain for the court to decide?
No.
Are you currently pregnant?
No.
All right, thank you. Mr. Hoggard, have you heard all the questions that I asked Ms. Hoggard?
Yes, sir.
And did you hear all of her answers?
I did.
Do you have any reason to believe that any of the answers that she gave were untrue?
No.
Do you agree with the parenting time and custody provisions that I outlined?
I do.
Do you agree as the father that they would be in the best interest of your child?
I do.
And you understand again, because of the equal number of overnights, that you also would not be entitled to receive any child support payments.
I do.
Further, under the judgment of divorce, you also would not be receiving any alimony or spousal support. You understand that you would also be waiving that forever and could not come back later and ask the court for that.
Yes, sir, I do.
And do you agree that all of the assets of the debts of the marriage have been divided and that there remain no issues for the court to decide?
Yes, I do. They're all divided.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. I'm signing the judgment of divorce with today's date, so your divorce will be final as of today. If either of you would like a copy of that judgment for your records, you can get that from the clerk's office. Ms. Hoggard, are you asking to have your last name changed?
No.
Okay. All right. Ms. Hoggard, did you have any questions at all?
I do not. No, thank you.
Mr. Hoggard, did you have any questions?
No, sir.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank
Okay, looks like we have the parties connected. This is Doobie versus Fuzi Doobie, file number 19924199905. We have both parties connected here by Zoom video. I have this set for entry of a final judgment of divorce today. Mr. Doobie, is that how you wanted to proceed?
Yes.
And Ms. Fuzi Doobie, is that how you wanted to proceed as well?
Yes.
Okay, if you both could raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can lower your hands. I'm going to be asking you each a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. Mr. Doobie, because you are the party filing in this case, my questions will go to you first. Mr. Doobie, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
And had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there has been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you signed the complaint?
Yes.
And does that remain true today?
Yes.
There is one minor child that was born of the marriage, is that correct?
Yes.
And under the proposed judgment of divorce, you would share joint legal custody of that child with Ms. Fuzi Doobie. She would have primary physical custody with parenting time pursuant to the order that was entered back in January. Is that your understanding?
Yes.
And as the father of that child, do you believe that that arrangement would be in your child's best interest?
Yes.
In terms of the assets or debts of the marriage, you and Ms. Fuzi Doobie have agreed on how to divide up all the assets and debts. Is that correct?
Yes.
As part of the judgment, you would not be receiving any alimony or spousal support. Is that correct?
Yes.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
Otherwise, any assets or debts will be divided according to the addendums that were signed by the both of you, addressing some personal property, the real property, and the income tax addendum. Is that correct?
Yes.
And have you reviewed all of those documents?
Yes.
Are you asking the court to divide up those items based on those addendums?
Yes.
Okay, thank you. Ms. Fuzi Doobie, have you heard all the questions that I asked Mr. Doobie?
I have.
And did you hear all of his answers?
Yes, I did.
Do you have any reason to believe that any of the answers that he gave were untrue?
I do not.
With regard to custody and parenting time of the minor child, do you agree with those custody and parenting time arrangements as I indicated to Mr. Doobie?
Yes, I do.
And as the mother, do you believe that those would be in your child's best interests?
Yes.
Are you currently pregnant?
No, I am not.
As I indicated with Mr. Doobie, under the judgment, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever, would not be able to come back later and ask the court for that.
Yes.
Okay. And in terms of the division of assets and debts, do you agree that you have settled those issues with Mr. Doobie according to the addendums that were submitted along with the judgment?
Yes.
And are you asking the court to divide those assets and debts pursuant to those addendums?
Yes, please.
Okay. And you've reviewed all of those?
I have. Yes.
All right. The court finds that the statutory grounds for divorce been met by the testimony of both the parties in this case. The court finds that the proposed judgment contains all the provisions required by statute, is equitable, and that the custody and parenting time provisions are in the best interest of the minor child. The court will grant the divorce on those terms. I'm signing the judgment with today's date, so your divorce will be final as of today. Ms. Fuzi Doobie, are you asking to have your last name changed?
Yes, I am.
Okay. See, is that something that you wrote into the judgment here?
I did.
Okay. All right, I do see that. So as of today, your name will be legally changed. If you need a copy of the judgment, you can get that today from the clerk's office, because you'll probably need that to change your identification and other documents.
Yes. Wonderful. Thank you.
Okay. Mr. Doobie, did you have any questions at all?
Nope.
Ms. Fuzi Doobie, did you have any questions?
I do not.
Okay, thank you. That's all for today. You're both free to disconnect at this time.
Thank you
Thank
so
you.
much.
Okay, we'll go on the record in Fable versus Fable, file number 2419899. The record should reflect that both parties are present today by Zoom video. This is set for a status conference in this case today. Looks like we have a temporary support order that's been entered. And so I just need to find out from the parties. Mr. Fable, you filed for the divorce in this case. Have you been able to reach any agreements with Ms. Fable regarding the division of the assets and debts of the marriage?
Yes.
Okay, and Ms. Fable, do you agree with that?
Yes.
It looks like we did have a hearing last month, in April, and I think maybe all we're waiting for is for the final judgment to be submitted. Is that something that, I don't see it in the file. Have you guys been able to do that? That take care of?
Oh yeah, it's still at the front of the court. We actually forgot about the that smile seminar we're supposed to go through, and we have it set up for later on today. So that's all.
Okay.
That's all they're waiting for.
Okay. Ms. Kraus, can you weigh in on that? Is that all that they need to do before they can get the judgment approved?
Yes, that appears. I do have the judgment. I will review it again, but we do need the completion of them attending Smile. Unfortunately, due to the ice storm last month, that was canceled. Tonight, there's one in Grayling.
Okay. Okay, so I will set this for a final hearing, and then you should be able to get things finalized on that date. I'm sorry, it sounds like the ice storm has kind of delayed things as it has for lots of people. So, but we'll get this back on the calendar as quick as we can so that we can get your case closed. Mr. Fable, do you have any questions at all?
No, sir.
Ms. Fable, do you have any questions?
No, sir.
Okay, so once you attend that SMILE program, just contact friend of the court, make sure that they get confirmation of that so that we can get the judgment submitted to the clerk's office, okay?
Okay.
Okay.
Okay, thank you. You're both free to disconnect at this time. Okay, looks like we have everybody connected. We'll go on the record in Van Til versus Van Til. This is file number 2520004. We have Tammy Van Til present by Zoom video. Mr. Blumberg, you're appearing on behalf of Timothy, is that correct?
Yes, Judge. He's appearing via Zoom from my office.
Okay. So this is set as an initial scheduling conference in this case. I think this is the party's first appearance before the court in this matter. Ms. Van Til, have you been able to talk to Mr. Van Til or Mr. Blumberg regarding dividing up the assets or debts of the marriage?
Well, I know that there is like debt from previous, and like I understand there's federal tax money this year got lowered due to debt from cashing out my Johnson 401k, but the check I received was used to also pay for the boat with the trailer bills to catch up from falling behind from having surgery last August and buying a new Blackstone flat top grill last June. My counter offer for him was that he can keep the remainder of the federal tax money, and that was loaded onto his Emerald Advance card, but I would like the boat and trailer and newer Blackstone flat top grill, and he can come get the other silver grill, 2 snowmobiles, and the rest of his belongings. Like, they're already set aside for him.
Okay, so it sounds like you guys are still kind of negotiating or trying to work things out. Is that a fair statement, Ms. Van Til?
Yeah, like he can come get his stuff, but I was just waiting for court and everything.
Mr. Blumberg?
Judge, my understanding is, and I think I heard recognition of the fact that Ms. Van Til had some pre-marital IRS obligation, which resulted in that amount being deducted from the joint refund. So there needs to be an accounting as to it relates to that. There are just personal property items that need to be resolved. So in terms of a scheduling order, Judge, I would be hoping that we could get this resolved in 30 days. My understanding is those items of personal property have not been made available to my client, but if Ms. Van Til will speak with me, maybe we can work through all of this.
Okay, so I'm gonna allow 30 days for the parties to try to resolve this on your own. We'll set it for a status conference final hearing in 30 days. If there hasn't been an agreement, then the court will consider at that time community mediation to resolve any outstanding issues. Mr. Blumberg, do you have any objection to that?
No, that's fine.
Okay, Ms. Van Til, do you have any objection to that?
Well, I will say I had an attorney that I talked to, but I didn't need to be represented. That I was told that looking over my taxes that there was an error, and when the amendment was filed, she did not account for the taxes that the empowerment company, which was through the Johnson 401k, had already withheld the taxes. So I'm gonna say that that's why I gave him my counter offer, because money got lowered. Plus when we filed jointly, we had my daughter on there, and that was from a previous marriage.
Yeah, so I think probably what you just need to do is share some of that paperwork with Mr. Bloomberg so that everybody has an understanding of, you know, the entire financial picture. So we'll give 30. Okay, good. So we'll give 30 days to do that. And again, if there's no settlement at that time, then we can consider mediation. So the court will send out notice of the date and time of that next hearing. Ms. Van Til will be by Zoom, just like we're doing today, okay?
Okay.
Did you have any questions at all?
Can we just have mediation like scheduled right now?
If you guys want to agree to do that, yeah, absolutely. There's nothing that would stop that.
My only concern, Judge, is there hasn't been any discovery. I don't have access to any of this information that Ms. Van Til is referencing. So if we're going to go to mediation, I'd like to have all the documents in place so that we can meaningfully discuss settlement.
Okay. So discovery will remain open. So to the extent you do need to engage in discovery, Mr. Blumberg, that is available. You know, I'm not going to order mediation until the parties have some time to exchange some documentation. If the parties want to agree to go to mediation prior to that and set that status conference out until after mediation, I don't have a problem doing that either as well. Just let the court know.
Yeah, I just feel more comfortable with mediation because I'm representing myself.
Sure. Yeah, of course. All right. Mr. Blumberg, anything further from your side today?
No, Judge, thank you.
All right, thank you. That's all for this hearing today, and both sides are free to disconnect at this time.
Thank you.
Just for the record, I accidentally clicked on Corson versus Corson. That would be the record for Van Til versus Van Til. Okay, looks like we have both parties connected on Corson versus Corson. That's file number 2520005. For the record, both parties are connected by Zoom video. This is an initial hearing in this divorce case. Just so the parties are aware, the purpose of this hearing is just to determine whether or not you've been able to reach any agreements regarding the division of any assets or debts of the marriage. And if not, what we can do for scheduling to get those issues resolved so that we can finalize the divorce. So Ms. Corson, as the filing party, have you been able to reach any agreements regarding dividing things up?
Everything's already divided and settled and actually done.
Okay. Mr. Corson, would you agree with that?
1000%. Yeah.
All right. So what I can do then is set this for a final hearing. There's one form that you need to submit prior to that hearing. It's called the judgment of divorce. You probably already have that form if you got a packet of documents online or through legal resources or something like that. Ms. Corson, do you see that form in your things?
I'm looking
Okay.
because it is a packet. Notice. I'm sorry. What was it?
It's called the judgment of divorce.
Judgment. Service. Yep.
Okay. So I just need you to fill that out, get that to Mr. Corson, and if you can both get that signed and then submit that to the clerk's office prior to the next hearing, which will be in about 30 days. If you have that document submitted prior to that time, then at that final hearing, I can take the testimony from both of you that I'm required to take, and we can finalize the divorce. But getting that document submitted is an important step. If I don't have that by the next hearing, we'll just have to push it out again. So
Okay.
if you can get that submitted, that'll allow me to finalize your divorce as quickly as I can. Ms. Corson, do you have any questions about that?
No, we can get this signed and sent in pretty quickly.
Yeah, this week, definitely.
Okay. All right. Mr. Corson, did you have any questions?
Not at all.
Okay. Thank you. That's all for today. We'll send out notice of the date and time of that final hearing. It'll be by Zoom, just like we're doing today. And you're both free to do.
Thank you.
Judge. I'm assuming it's okay to leave.
I'm sorry. I did. Yeah, you can both
Okay,
disconnect.
just wanted to. I didn't want to be the first one and be like, "This is weird." Okay,
I was
thank you.
trying to find the end call button.
Okay.
I might have said it too softly there. So yeah, you're free to disconnect. Okay, whoever's signing in on the Motorola device, can you unmute, please? Hi, can you tell me your name?
Christopher Peters.
Okay. All right. So Anna, you're going to need to connect the audio on your device. Your video is working, but there we go. Now I just need you to unmute, please. Okay, great. All right, we have both parties present. This is Peters versus Peters, file number 2419704. This is set for a status conference today. In this case, the record should reflect that both parties are present by Zoom video. I think we've been trying to get this divorce finalized for a while. I know the ice storm was a problem last time. I still need to get a final judgment of divorce from either of you. So can you guys tell me where that's at, Miss Peters? Have you been able to get that document?
Yes, I do have all of the paperwork for that. I got it finished up this past week, and the only thing I needed to do was to set up the smile program thing, and I did. I do have that set for tonight for a grayling. I let the friend of the court know too. So that's the only thing that Tara at friend of the court said that I needed to have done before I send in the paperwork.
Okay, all right.
So I'm going to be doing that today.
Okay, great. Mr. Peters, have you taken care of that part of it?
Yeah, I'm actually on the same page as her. I talked to her about an hour before this. So we're both actually in that class tonight, and then everything will be sent in, and hopefully that'll be it.
All right, great. Okay, perfect. So I will set this for another final hearing at my next available date. Just make sure that you submit those documents prior to that hearing, and then we can finalize things at that time. Ms. Peters, any questions?
I do not.
Mr. Peters, did you have any questions?
No, I'm good.
Okay, great. Thank you both. You're both free to disconnect at this time.
Awesome. Thank you.
Judge, can we get Mr. Peters' updated address? It looks like we've got a couple that's come back to us.
That
Mr. Peters, hold on one second. I don't want you to put that out on the audio right now.
Yeah.
But can you contact the clerk's office and notify them?
Yeah, I had actually just called before, but I was gonna run late for this meeting, so I was gonna call afterwards and give them that address.
Okay, great. Thank you.
Yep.
Okay, you're both free to disconnect at this time.
Awesome. Thank you.
Okay, ma'am, can you unmute, please? All right, and are you Rebecca DeMarzo Nowicki?
Yes.
Okay. I have this set for a final hearing today to enter a judgment of divorce. Is that how you wanted to proceed today?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. All right, this is set for a final judgment today. We do have the plaintiff present today. This was set for hearing at 10 o'clock. It's now 10:21. The defendant has not appeared. It does not appear from the answer filed by the defendant that he's contesting anything about the divorce. He was served with notice of the date and time of today's hearing. Again, has not appeared. I also have a proposed judgment that's been signed by both parties. So the court is going to proceed with the divorce. Ms. DeMarzo Nowicki, I'm going to be asking you a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So my first question is, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever, that you would not be able to come back later and ask the court for that.
Yes.
Under the judgment, it also indicates that you and Mr. Nowicki have already divided up any assets or debts in the marriage. Is that true?
Yes.
Are there any issues regarding dividing up any property that remain for the court to decide?
No.
And you're asking to have your last name changed to DeMarzo, is that correct?
Yeah.
The court finds that the statutory grounds for divorce have been met by the testimony of Ms. DeMarzo. The court will grant the divorce. I've signed that judgment. Your divorce is final as of today. So, and your name will be legally changed back to just DeMarzo. So if you need to change your identification or other documents, you'll need to get a copy of the judgment from the clerk's office here in order to do that, okay?
Okay. Thank you.
Did you have any questions at all?
No.
Okay, thank you. That's all for today, and you're free to disconnect at this time. Okay, looks like we've got both counsel connected. So we'll go on the record in Cruz versus Cruz, file number 2319351. If I could just have both counsel put your appearances on, please.
Good morning, Judge Elliott Blumberg on behalf of the plaintiff, Danny Cruz.
Good morning, Your Honor. May it please the court, Chris Kolumchek on behalf of the defendant, Carrie Cruz.
All right, and I do see Ms. Cruz is connected. Mr. Blumberg, this is set for a status conference today. How did you want to proceed?
Well, Judge, my client's not present because he is working in the Middle East. I think he's in Qatar as we speak. The status of the case is that the most recently we were before you on some issues arising from mediation. you have made a ruling on that matter. And so I think at this point, a judgment of divorce incorporating your ruling needs to be done. I had spoken with counsel's paralegal on Friday. I sent over a proposed judgment that I had prepared when there was prior counsel involved in the case. And I don't know if they were going to revise that or what their position is as it relates to that document.
Thank you.
Your Honor, there's some serious information that's come to our attention, and I would ask for a private, I guess, approaching the bench in a breakout room, so to speak, between both counsels and Your Honor.
All right, Mr. Blumberg, do you have any objection to that?
No, I didn't know you could even do that. So fine.
Well, I'm not sure I can. I'm going to try. Let's see what happens here. Hold on. I'm going to go off the record first of all.